So our panel today consists of 2 people so far, and hopefully they will soon become 3 people. And that's Alison Tilley, who's the director of the organization Judges Matter. And we also have with us here Dan Mafora, who is the Advocacy Research Officer at the Council for the Advancement of the South African Constitution, CASAC. Both Alison and Dan, and Mbekezeli Benjamin, who I hope will join us shortly, also with Alison at Judges Matter, have been watching the Judicial Service Commission for many years, attending its hearings in many cases, and really have analyzed it in a number of articles. And you've seen them on the Daily Maverick and in the Sunday Times and in Business Day, etc., etc. So I doubt whether there are any 3 probably more knowledgeable people in the country about the doings and the goings and the toings and the froings of the Judicial Service Commission. And our question today is, what are we going to do about the JSC? I think we can take it for granted. We don't have to establish that things are not 100% hunky-dory with the JSC. That's easy to assert. Much more difficult is, what are we going to do? What do we need to do? And how do we do it? I see Mbekezeli has joined us now, so we just need to promote him, as it says, to panelist, and then we'll be ready to go. I'm going to kind of lead the discussion with a number of questions. Questions have been circulated to the panelists so they can prepare. And once that's finished, I'm going to invite everyone to contribute questions. In fact, you're free to put your questions in the Q&A or the chat box at any time that you want to, and we'll add that into the discussion. We're doing it in this particular format, the panel discussion type format, because of the video. It's much easier just to have this screen on a video rather than a screen that has a couple of dozen tiny little faces and icons and whatnot, with all due respect, cluttering up the video. So you get to look at the 4 of us. Okay, so let's make a start just by reminding ourselves, and perhaps 1 or 2 people aren't fully familiar with what the JSC is there for, what its essential tasks are. So Dan, can I come to you with that first question? What are the essential tasks of the JSC, and what is it for?
Thanks so much, Mike, for having me and for setting up this discussion. So the JSC is established by the Constitution and is given the role or the function or the responsibility of appointing judges to the superior courts of the country. So the JSC is responsible for interviewing, for vetting, and ultimately recommending candidates for appointment to the High Court, the Supreme Court of Appeal, the Constitutional Court, several other specialist courts like the Labour Court and the Labour Appeals Court and the Competition Appeals Court. And so that's broadly what it is responsible for, or that is its main role. But it also has a disciplinary function. Part of their role is to oversee the conduct of judges and make sure that any complaints that are filed against judges about their behavior or about any kind of undesirable conduct can be settled through its own mechanisms that it establishes in terms of the JSC Act. So and the Constitution as well says that the JSC has the power or is given the role of advising the government on any matter that pertains to the administration of justice. And so broadly, that's the role of the JSC, and that's the work that it does. Yeah.
Thanks, Dan. The JSC is essentially was brought into being by Section 178 of the Constitution, which says there is a Judicial Service Commission, and then it goes on in subsection 1 to list the makeup of that commission: the Chief Justice, who presides, President of the Constitutional Court. Of course, that's changed now, those terminologies. So President of the Supreme Court of Appeal, one judge, President designated by the judge as President, Justice Minister, representatives of the advocates and attorneys professions, and so on, certain number of members of Parliament and of the NCOP, and then 4 persons designated by the President. Alison, on paper, is the JSC well designed? Is it fit for its purpose? Or would you say that there were problems with its constitution, the way that it was made up, even from the beginning?
It was controversial from the beginning. And I think the reason it was controversial is because in most countries that have a legal system like ours, you tend to have judges appointing other judges. So it's very much a tap on the shoulder system where we're a relatively small group of people. We know each other, and you know, we put people forward from the profession to be a judge. But we had a very peculiar set of challenges at that point. We had a bench that had been, you know, and I know it's unfortunate in relation to some judges who did try very hard to instill the rule of law and respect for human rights, but it was effectively an apartheid judiciary. Yeah. And the idea that apartheid judiciary should replicate itself going forward in a new democratic South Africa, and then be able to really look at the Constitution and make those rights in the Constitution real, that was a concern. So the idea was then to create a body that had more politicians than most, for the very purpose of ensuring the transformation of the judiciary and the implementation of the Constitution, and to make sure that there wouldn't be a pushback from a group of older, more conservative white men who would prevent transformation.
Now we are, what, 25 years on, more or less, from when it was put together like that. Do you think it needs restructuring in terms of its personnel? And if so, can that actually be done without the whole rigmarole of the constitutional amendment?
Well, I think perhaps if I was a doctor, I would say, well, we need to diagnose before we prescribe. Let's not dish out the antibiotics until we're sure, you know, what we're dealing with. I think it is certainly tempting to say that the way it is constructed at the moment is failing. It is at least too big. I think that is something that's perhaps uncontroversial. Of course, who exactly then makes up such a smaller JSC then becomes the difficulty, and it might well then need constitutional amendment, failing which there may be other ways that we can manage the processes that the JSC is responsible for, perhaps without going to the question of the makeup of the body.
Okay, Mbex, let me come to you with this one then. Still looking at the question of personnel, we have a number of political appointees. We've got the Minister of Justice. We've got 6 members of the National Assembly, and it's stipulated that 3 of them at least must be from opposition parties. And then we have 4 people from the National Council of Provinces, effectively MPs. And then the 4 that can be appointed by the president. Some of them in the past, I think, have also been politicians, although they are not now politicians. But the political appointee, shall we say, on the JSC, what's your take on their performance lately?
Well, I think there's a temptation to draw a line between the political appointees and say that they are the ones who are politicizing the JSC versus other people, maybe the lawyers who are apolitical. But from what we've seen from the JSC over the years is that the politicization of the JSC is not only the politicians or the members of parliament. So I think if we're thinking about what the role and function of the MPs are, I think we should look beyond just the politicization. For example, part of the reason that Alison put forward is that the members of parliament were suspicious at the beginning of the judiciary and the legal profession as a whole, and it reproducing itself along conservative lines. So the MPs were meant to bring a fresh perspective. They were supposed to act as public representatives, which means they are supposed to bring to the JSC the concerns of ordinary members of the public who might interact with the judiciary. And so that was the entire purpose from the get-go. Now, whether or not they've fulfilled this role, I think is up for debate. But what we've seen is that there are some members of parliament who are very much focused on this task. They always ask relevant questions. There were times at which, for example, Minister Didiza, when she was a member of the JSC, she would ask very pointed questions of gender, how the candidates understand gender, how they understand crime and gender and the law and gender. All of those were interesting questions that were perfect for a Judicial Service Commission interview. But we've seen sometimes a hijacking of the JSC and the politicians, and sometimes the politicians who are sometimes called lawyers, they hijack the JSC and try and push their own political agendas that do not relate to testing whether people are fit for office. So that's the conundrum that we currently face, and which is why we are advocating for there to be some sort of criteria to guide how these interviews are conducted.
Okay, let's just go a little bit further into that. You mentioned you know, the lawyers who also appear to be politicians. So we're not going to beat around the bush. We saw a kind of double act a few weeks ago between Julius Malema and Dali Mpofu. I mean, just to start with your comment on the strange fact that someone who was until very recently, last year, I think, the chairperson of the EFF pops up suddenly on a body like this representing the legal profession, and supposedly has, you know, cast away his EFF hat. While he does that, that seems incongruous. But nevertheless, the two of them were a double act. So that brings in the legal profession's representatives. Then we know that some of the politicians have been politicizing things. You're telling us that some of the lawyers also are politicizing. What about the responsibility of the legal profession to appoint people or designate people to represent it who are going to do a proper, as objective as possible job on behalf of the profession? What would you say about that?
Well, I think there is a huge responsibility on the legal profession, but on all other bodies that nominate people to sit on the JSC. They all have a responsibility to send people who will be focused on the task of selecting only the very best lawyers to become judges or promoting judges. So everyone has that responsibility, including the MPs, because like I said, they don't sit there as members of political parties. They don't represent their political parties. They are public representatives and should do a good job at representing the interests of the public. So I think as a general point, everyone should send only the very best representatives. But yes, you are quite right that there is a special responsibility on, for example, the legal profession to ensure that their representatives are particularly focused on testing out the concerns of the legal profession who are in and out of the courts and who sit before these judges on a daily basis. But I could also extend that to, for example, the representatives of the president. We've seen in the last couple of interviews, for example, Commissioner Madonsela, who represents the president and the JSC, he's brought on some issues that are not always in relation to the job of Chief Justice, for example. We saw his line of questioning was a little bit more politicized, in that he was asking Justice Mlambo, for example, about why is it that cases that involve President Ramaphosa go to his court in Pretoria versus those that involved former President Zuma used to go to the Western Cape High Court. That is not a legal question, and certainly not one that asks a legal response. It is a more political question. So that kind of behavior and that kind of representation, is it really fulfilling the nominating body, the president? The same could be said for other lawyers on the JSC who sometimes traffic in professional politics, so politics of the legal profession that do not necessarily relate to the person's ability to be a judge, but they animate the debates that are happening in the legal profession. And we've seen that quite often from the representatives of the attorneys profession and others who are members of the Legal Practice Council. So I think everyone just needs to take a step back and ask themselves, what are we doing? What are we looking for? And how can we best fulfill this task of appointing judges? So I think that's what needs to happen at the JSC right now.
I'll come back a little bit later, I think, to the question of what happens if people don't do that, if people don't, if JSC members, commissioners, don't go back to their real task. We'll deal with that a bit later, but I want to just move to the question of the leadership and the chairing of the body. And Dan, I'm going to ask you firstly for your comments on this. Judge Petse, who chaired this set of hearings, and again, strange, unusual situation where the Chief Justice has retired. The acting Chief Justice couldn't do it because he was a candidate. The President of the Supreme Court of Appeal couldn't do it because she was a candidate. So it ended up falling to the Deputy President of the SCA. I assume the first time he'd ever had to chair a JSC meeting. And he came in for some criticism, particularly for not clamping down on the questioning of Judge Mlambo around the sexual assault rumor and so on. But in the past also, in a previous set of hearings, Judge Mogoeng was heavily criticized for pretty much entering the arena and putting it to one of the candidates that she'd had some sort of improper, not relationship, but interactions with Minister Pravin Gordhan, and so on. Do we have a problem with the caliber of leadership of the JSC, of the way that the meetings are run and chaired? Does that need particular attention?
So I think that the leadership of the JSC is obviously important, especially given the composition, as we've spoken about, of politicians and their tendency to want to, just be politicians and score political points and litigate or re-litigate matters and raise issues or grievances that they have with particular candidates. It is important to have someone who can take charge of the proceedings and rein in commissioners when they start asking questions that are not entirely relevant, or when they come down unfairly on candidates. What we've seen in the past, as you've alluded to, is kind of like a hands-off approach to kind of let commissioners ask questions and let them go on for quite a long time, allow them to make all of these preambles that kind of put out their own statements to candidates without actually engaging them or asking them any questions. It certainly was a concern. I think the chairing of the JSC during these last interviews for the Chief Justice's position was particularly, for lack of a better word, poor. We saw, of course, the smuggling in of the rumors, as you said, into official record, and then a reaction about an hour and a half later, when the conversation or the interview had kind of degenerated into a mudslinging match. And so the real problem is that because there aren't any rules that govern the interview process, it's kind of an ad hoc process that whose conduct is going to be ad hoc. It's going to depend on who is chairing on that day, and so until we have some semblance of rules of procedure, rules of practice, where commissioners know what they can or cannot ask, how they can or cannot bring up issues, we will have a problem, because there are some very strong personalities on the JSC, and sometimes that also plays out. We saw Justice Mbekezeli get into quite tense interactions and tense exchanges with, for example, Commissioner Malema, about the kinds of questions that he was asking. But because there isn't anything that gives him the power or that guides his conduct or his own chairing of the commission, it's easy to turn it into something that looks like a censoring or an unfairness on the part of the chair, kind of protecting candidates and all of those sorts of things. So what we need is a framework, rules of procedure, something, criteria. What kind of questions can you ask? Which candidates for which courts? What are you actually looking for? That the existence of those instruments will help the person chairing the commission to be able to get a hold, to take control of the proceedings and make sure that you do not end up with a situation where you have, the judge president of the Gauteng High Court being attacked and kind of vilified in that way without any kind of actual basis, without any basis in official documentation or whatever. So the short point is the problem may be the individual judges who lead the commission, but it actually might be more structural and more systematic about the JSC's failure to actually create rules for its own functioning.
Just still on this point, a bit of a slight aside issue, but I think it might be relevant. It struck me that there's almost a built-in potential for conflict of interest by having the Chief Justice or the President of the SCA chairing the meetings. The Chief Justice, for example, has to work with everybody on the Constitutional Court, the SCA President similarly with that court. There could at least be accusations made, that a Chief Justice had favored or disfavored particular candidates for posts on the Con Court and similarly for the SCA. Wouldn't it have been perhaps a better idea to provide that the JSC be chaired by a retired judge who has no personal interest in the makeup of courts anymore? Any one of you feels that if that's worthwhile answering?
If I could venture a guess, I don't think there is a judge or a lawyer who has no interest in the composition of the courts. You'll find that there are retired judges on this very webinar, not because they don't have anything to do, but because they care very much about the composition of our courts. But more seriously, we do need a sort of a trained chairperson on the commission, and I think I don't think we can really rule out that the Chief Justice should sit as chairperson, because in the past year, for example, there have been 3 chairpersons of the JSC. First, it was Justice Mogoeng, who unfortunately did not chair that session very well. Then there was Justice Zondo, who did a better job at leading the JSC in that interview round in October. Those interviews were much more dignified. He had the authority, the legitimacy, and he was attentive to the kinds of questions that were asked. And he would sometimes intervene very quickly when the commissioner was straying off course. So it's not necessarily that the Chief Justice should never be appointed or that there shouldn't be another chair. But I think the idea of the chairperson is that they have the authority and the gravitas to be able to chair the institution. And a professional chairperson who is not a judge, for example, or who is not in the position of Chief Justice will struggle, I think, to command the respect and the respect of the commissioners in the room.
Okay, let's come to the question then of civil society. Alison, I'm going to put this to you first of all. Should civil society, which I know is a very broad sector, have a presence on the JSC? I'm thinking of organizations like yours, for example. And it strikes me that the body would benefit greatly from having a couple of people from outside the world of politics and from outside the world of law specifically. And the subsection 1781J that allows the president to appoint 4 people would be the obvious vehicle for that. Would this be a good idea?
You know, I used to think not. I used to think that really, you know, we really wanted people who were lawyers and legally trained and active, you know, in the courts, really trying to find the best candidates, and that really that background was necessary. But I think we have seen, and particularly through a number of the politicians who've been commissioners who've been very good, that isn't actually the be all and end all of asking the right kinds of questions. And I think that would be a vehicle through which you could introduce a different voice and a different kind of questioning about the relevance of judges, and particularly in a constitutional democracy where the Constitution has such a wide reach. You know, the role of judges in that constitutional democracy is contested, and I think that would be a really good place to have some people who are thinking about it. But I'm afraid I don't really think it's about the individuals in the room and whether they are, you know, better intentioned or better placed. There's something quite broken about the rules themselves that I think we really have to come back to. And yes, there is the composition, and yes, that's a constitutional matter, but things like, you know, what kind of judge are we looking for? What are the criteria? A code of conduct. I mean, a code of conduct is really something that can be done, you know, in a matter of weeks, if need be. These are urgent interventions, which could be done relatively quickly. And I think we had acknowledgement from some of the candidates that these are changes that need to be made before the next round of interviews, which is of course relentlessly bearing down on us in April.
I want to remind everybody about the little evaluation questionnaire which has been posted in the chat box, and also invite you to add your questions and comments in the chat box or the Q&A. Just following on from that, Alison, and I'm going to stay with you, you published an article immediately after those hearings in the Sunday Times, which had the headline JSC overdue for reform on several levels. I know you didn't write the headline, but that's what it's about. And you mentioned that the JSC had 3 jobs. The third one was to figure out how to put its findings to the president, and we'll come to that later. But the first 2 tasks for those hearings, you say, was firstly was to decide the criteria by which the candidates should be measured, and the second was to interview the candidates in line with those criteria. Now, a lot of commentators have spoken about this, that the questions seem to be all over the place. Judge Meyer got asked a certain line of questioning. A lot of it had to do with her gender. Very little of it had to do with her jurisprudence. And then, of course, we know that Mlambo was asked extremely contentious questions. I think Judge Madlanga, who had the first interviews, was asked far more on some of his own judgments and his legal philosophy, etc. But nevertheless, that you make the point, many commentators have made the point, that the Commission doesn't seem to have an established, sort of standardized, uniform approach to questioning. What are your recommendations in that respect?
Well, I think the first thing that you have to sit down, and like any of us, if we were going to advertise a job, the first thing you have to figure out is what that job is. And there have been various attempts to do that, but the last one, probably in 2010, what is the role of a judge? What does a judge do? What are the most important qualities you need in order to be a judge? I think these are some of the questions that have to be answered, because once you've done that, it's only then that you can start testing for that experience, those skills, those qualities, and you can really start putting interesting questions that allow the candidate to show whether or not they meet those criteria. And I think one of the things that the Jsc commissioners will say as well, they really don't want to be bound to a list of questions, and they don't want to have to ask the same questions over and over again. And I think my answer to that is, I really am not interested in whether or not you are bored. That is not of any interest to me. The question is the candidate being afforded the opportunity to answer the questions that will show whether or not they have the right stuff for the job? And that is the job of the Jsc. And really the issue is, suggesting that, well, we can put, questions A to H to one candidate and H to P to another. I mean, it's any HR practitioner will tell you it's absolute nonsense. And I really think that from that point of view, there really needs to be a bit of a rethink on the part of the Jsc of what their job is and what they're there to do.
The commissioners seem to have, I picked up, supposedly have sort of time limits for their questioning, and at a certain point, some commissioners were being told, you've exceeded your time by 5 minutes or 10 minutes or whatever. But at another point, it looked like some of those time limits had gone completely out of the window, and people were giving long lectures. What's going on there? And that's a technicality, but it was just interesting.
I mean, I think one of the, I don't know, highlight or a low light of the last round of interviews is where one of the members shouted, "You must take control of your meeting, Chairperson." I think when you hear that, you know that any kind of semblance of order and rules and how long you need to speak for has really broken down. The process theoretically allows you to raise concerns about a candidate. You put them to the Jsc well ahead of time. The candidate is allowed to have a look at them, and then they deal with those in the interviews. No new issues should be raised. That appears to be a rule that was more honored in the breach. The commissioners took the view that, yes, that was true for members of the public, but for them, they could raise anything in the interview without notice to the candidates. Now, that's a rather novel interpretation of that rule. So again, we come back to this question of, if you don't have a code of conduct and if you don't have clear criteria, it really, the last round has just showed the possibility for the thing degenerating into a shouting match.
And a lot of use was made of the phrase follow up. So this was a follow-up question, and that seemed to open the floodgates in the way that point of order does sometimes in the National Assembly. Once you've stood up and said point of order, you have the floor for seemingly as long as you like, and if you are shut down, you say that in itself gives rise to another point of order. So, okay. Moving on, these particular interviews for Chief Justice, Mbex, I know you were also quoted in the press, and correct me if I'm wrong, and many other people were too, saying that in a way, whichever candidate emerges and is ultimately appointed by the president, and I kind of hoped, by the way, that having this panel discussion a couple of weeks after the recommendation was made, we might actually have a new CJ by now. We talk about him or her, but we can't. But anyway, the notion is that whoever is appointed is already kind of tainted. If Judge Meyer is appointed, people will say, well, she got there because some of the other candidates were ambushed and had their candidacies more or less extinguished by whatever, by the Malema Mpofu Double Act or something else. Others will always argue perhaps that she's got there because she's a woman. And so conversely, if the president were to appoint one of the other three, he's going to have a hard time explaining why he didn't take the opportunity to appoint our first Black woman Chief Justice, etc. So is it true? Has the appointment been somehow forever tainted by the kind of circus that we observed during the hearings, or would you say not?
I would say not. I think the shambolic nature of these interviews did not and does not reflect in any way on the candidates themselves. I think this round of interviews for the Chief Justice, we were blessed, if I can say that, to have 4 exceptional judges put themselves forward for the job. I think any of them could be appointed as Chief Justice and they would do a decent job. But at the same time, though, we must critique and criticize the way that the JSC went about doing the job. And it does now create a shadow or some sort of cloud over the appointment process. The president right now is considering the appointment of the Chief Justice, but because of how the JSC went about doing the interviews and then the subsequent recommendation, his hands are effectively tied. He does have some wiggle room. He could choose an alternative candidate, but he would have extremely strong reasons to move away from Justice Maya. And coming into the interviews, a lot of people were saying that she is the front runner to be Chief Justice. So, and that's not necessarily because she's a woman, but because of her track record in the judiciary. Oh. So, look, the president is in a tough position. He has said that the decision ultimately rests with him. But I wouldn't like to say that the way the JSC performed is a reflection on the candidates. In fact, any candidate that comes out of this, I think, has their work cut out in terms of fixing the JSC and how it does things.
That's an encouraging answer. And well, let's wait and see who is appointed and what happens. I think I'm happy to know that some of the organizations that had threatened at one stage to take the whole matter on review seem to have decided against doing that. That might have ended up doing perhaps more harm to the whole system than good. But perhaps others will disagree with me. Dan, you were also busy writing, and you had an article in Business Day under the heading "A Requiem for the Judicial Service Commission." Sounds like you want to bury it, but in there you make the point that the JSC has for a long time been used as a platform for partisan politics. And this is just another installment in that sorry saga. I want to ask you not so much about the politicization of the process and so on, but is there a deeper agenda at work in the way that some politicians, and it's obvious that Julius Malema is one of them, probably the most active of them, are they trying to push the whole process, the whole body in a particular direction, or is it just an opportunistic thing that we like this one and we don't like that one? Is there a deeper political agenda at work here?
So I certainly think that there is a vision of what the JSC should achieve or can achieve, right, under certain conditions. And we see this whenever there's a candidate who may be considered politically divisive, that there always seems to be a more robust, a more intensive, as it were, a more intense questioning of that candidate. And certainly in the case of Judge President Mlambo, it was very clear that there had been a sort of a coordination in the kinds of questions that were being asked, who was going to follow up with what questions at what point, between 3 particular commissioners, Commissioner Malema, Commissioner Mbofu, and Commissioner Madonsela, who were kind of like, as you were talking about follow-up questions and things like that, would hop on to the trail of questions that were asked by the previous commissioner, and certainly to drive home a point even though a lot of the things that were being asked were completely baseless. I mean, Judge Mlambo was asked about whether or not, you know, his court was captured or whether he was on the payroll of the president. And at some point, I remember, you know, one of the commissioners chiming in to say, well, you know, you're being questioned a lot about your judgments, which have been appealed and have been upheld by the Constitutional Court. Does that mean everyone else involved in those decisions is also part of this paid of the payroll, right? So there is a sense in which it is opportunistic in order to embarrass, in order to kind of, outshow, belittle candidates who are perceived as politically divisive figures. But I do think that there certainly is an intentional drive towards using the JSC to achieve particular ends. It doesn't really matter or who becomes the target of that campaign, depends on who comes before the JSC. I think there are certain candidates who have been appointed or have gone through the process and should certainly have been questioned about some of the things in their careers, some of the work they've done, or some of their conduct as professionals, and weren't, because they were just not interesting enough, or this, you know, they didn't pose any difficulty for the commissioners, and certainly it is concerning that, you know, a lot of the lawyers still on the JSC are more interested in politics. I mean, they are actually they're supposed to be there to ask some of the more technical legal questions of these candidates, because they encounter them in courts every day. But we see them aligning themselves or choosing to engage rather in politics and seemingly to achieve particular goals. So I do think it's a little bit of both, that the JSC is seen as quite a powerful body, which it is, and for that reason opens its or there are opportunities or attempts to usurp or to co-opt its functions to achieve more nakedly political goals. Yeah.
Okay. Last point question from my side is, you know, where do we go to from here? We could just sit back and hope that we get a CJ appointed soon, in time to chair the next round of hearings in April, and we just sort of let the dust settle and hope that she or he does a better job, a firmer job of chairing, and then we can all be happy again. But we know that there are structural issues. So do we need to press for changes? And if so, how do we do that? What are the mechanisms? How do we try to address the situation? Would you like to start, Alison, on that?
Well, I think the first thing that I would have to say, it's 135 days since we had a permanent Chief Justice. So I think there's one decision sitting on one person's desk that needs to be made, and it needs to be made today, and that's the president. He needs to move and he needs to appoint the new Chief Justice now. That being done, I think there are a number of things that need to be done ahead of the April interviews. And one of them is establish criteria for the various positions being appointed for. And there needs to be rules of procedure, a code of conduct that would actually contain the proceedings, if, you know, so that it doesn't matter who's chairing it, that there are clear parameters within which commissioners can ask questions. And those things have to be done really urgently. As I say, April, it's around the corner. These things take time. These need to be in place before April happens. April interviews cannot go ahead in the current framework, in the current context. It simply is not tenable. And I think that's the question is, are policymakers and decision makers listening to the message that this is urgent and must happen. And I don't mean tomorrow. I mean, literally, the president needs to pick up whatever pen he uses and sign whatever piece of paper it is. That there is no more time. We have wasted years watching the JSC faff around, and it's absolutely untenable, and it has to stop. And those are the things that have to be done between now and April in order to get the show more or less back on the road.
Bex, anything to add to that?
Well, I echo all of Alison's point on the JSC setting clear criteria, on the JSC having a code of conduct for commissioners, and the JSC having written rules of procedure. Those I think are the three key reforms that need to happen at the JSC as soon as possible, well, urgently. But the good thing that has happened in these last interviews is that we've gotten two things. Number one is one of the candidates, Justice Maya, mentioned that the JSC is broken and she would be willing to institute some of these reforms. She has heard civil society and the broader public raising concerns about this, and she said if she is appointed, she will get to doing those reforms as soon as possible. The second thing is that the JSC itself, through its spokesperson, Dalimpofu, said that as soon as the new Chief Justice is appointed, the JSC will go to a workshop where they will discuss some of these issues, particularly a written criteria. He said that the JSC now realizes that a lot of people in the public do not understand or do not know that there is a criterion and it's not clear. So they will further clarify. And by that, I think he means they will write it down and publish it, which is an important thing that needs to happen. Like Alison said, it can't wait until April. It needs to be done now. But I think we must also, while thinking about how the JSC should change and what should happen, we must also acknowledge that the JSC itself is made up of different individuals. And from our interactions with some of them, they are really committed to doing what is right in terms of putting the institution back to its constitutional function. And that gives us a lot of hope.
Okay, thank you. That's optimism. Dan, from your side, optimism or pessimism or just realism?
I think I'm equally optimist, and I also think that one thing that did come out of these interviews as well is an awareness by the professional bodies that are represented on the JSC that there needs to be urgent change. There needs to be serious thought given to the people that they sent there, and an understanding of their role when they place their candidates or their nominees on the JSC. I think that some of the more appalling behavior at these past interviews came from lawyers and the bars and the legal practice councils and the law societies need to take responsibility for who they put up for nomination to the JSC. And so that is one positive change that could likely come up or come out of this process. And so the JSC does seem, or at least portions of the JSC do seem to be committed to actually taking their role seriously. And I just wanted to, come back to the point of a code of conduct. Recently, the Joint Committee on Members' Interests in Parliament found, Honorable Malema guilty of breaching the code of ethics for members because he questioned a candidate about a judgment that he was involved in as a litigant. And this is obviously a rule that needs to be put into a code of conduct that applies specifically to JSC commissioners, because Mr. Malema has now taken that ruling to court and wants to have it overthrown because he says the committee does not have jurisdiction over this, his conduct at the JSC, even though he, represents a parliament in that body, right? And so it's important that the JSC itself, because it doesn't actually have rules that govern behavior and conduct of commissioners, leaves itself open to the kind of opportunism that is displayed by Mr. Malima's refusal to take ownership of the fact that he did behave in ways that were improper. And so I do think that there seems to be an earnest attempt to reform the JSC, to put up the best people that we can, and to try and make it work as best as it can in its current form.
Just one quick extra point there. You've all mentioned the idea of a code of conduct. Do you know if anyone, any body, grouping of organizations, people have tried to draft a code of conduct that could be submitted as a starting point? Has that happened?
So, well, we at Judges Matter have, on issue of criteria, for example, we have put forward a criteria that the JSC could use and that it could quickly adopt. We are thinking about a code of conduct that could be instituted in the JSC. Of course, we will speak to other friends in civil society in formulating this code of conduct. But in terms of criteria, we do have a piece of paper ready to go.
Right, thank you very much to all three of you. I'm going to open it now and see if there are any questions or comments. We haven't had anything posted in the Q&A. There is one idea has been raised in the chat box, which I hope I can hope I understand correctly, from Mukesh. Mukesh and I go back quite a long way, and I should be able to understand what he's driving at, but making the point that, you know, the JSC appeared at one stage to be a success story, and that maybe we could learn from it when it comes to other areas of society. I guess it's about having an independent body to oversee a very important process of state. And could this be adapted or learned from in other areas, for example, stewardship of land, instead of placing it directly under state control or under private control? Could we have other bodies like this to assist us in you know, from an independent kind of point of view? Anybody want to tackle that one? Alison.
I just want to say, I mean, it's perhaps not directly about this question, but there's a tendency to say, well, you know, lawyers and judges should be dragged into to other areas of work and policy and issues, and I think it's particularly in relation to judges and retired judges. I have a bit of a knee-jerk reaction, which is to sort of say, to leave them out. Don't, for heaven's sake, try to drag retired judges into everything, because they are just judges. I mean, with the greatest respect. You know, I think we need to leave the judges to do the judging, and you know, be confident that there is competent, ethical, principled leadership in many places in our society.
I think what Mukesh is probably driving at is not to have a body made up of lawyers and judges to deal with questions like land, but rather a body that stands apart from the state itself and stands apart from private interests. And I mean, we do in this country have this very interesting set of things that we call the Chapter 9 institutions. I mean, they're constitutionally interesting and innovative in many ways. And the JSC, I know it's not a unique body, but if we compare the way that we've gone about appointing our judges to what happens, for example, in the US or the UK, you mentioned the tap on the shoulder, and the hopelessly politicized process in the US, then I think we're still winning, I mean, by a country mile. So maybe we could learn from this for other important decisions. Bex?
Yeah, I think part of the lessons from the JSC and the successes of the JSC are being replicated in different ways, especially when it comes to appointments. You'll recall for the head of the NPA, the National Director of Public Prosecutions, when that position was vacant and there needed to be an appointment, the president decided to open the process up He set up a panel that did public interviews. There were different candidates who were interviewed. And from there, Shamila Batoyi was appointed as the head of the NPA. A similar process is being contemplated for the appointment of the police commissioner. Many people are saying it's the current system where a random police officer is just selected to be national commissioner, sometimes even outside of the police. You'll remember Ria Pierre, she had no police experience, or even Mbekezeli was put forward as national commissioner without ever having run a single organization in their lives. So a similar process is now, many people, many voices I've heard are calling for a similar JSC-like process when it comes to the appointment of the national commissioner. And I think that's one lesson that we get from a JSC-like process that can be replicated to other places, but that seems to be proving its worth in terms of making an important decision on appointing people to important institutions.
Okay, then I'm going to wrap it up at that point. We've had a solid hour, and I think we covered a lot of territory. So on everyone's behalf, my thanks to Alison, Mbekezeli, and Dan, the panelists, for giving up your time this afternoon and for informing us.